Abusia mami musa wasembia nyanya bia photocopy of a year will ebi ohonu mana me ne ukasa abusia timliga wife for the nkomo bia ba beto abonten a ensem mo kan se mami Akosua Serwaa de enti aye mami ahofefo ni ni abli ni na yetia wa kire se dad Lumba a will awo ye no wo photocopy e wo honu ma ensem beto abonten no ase eye yetirimu kesere ne kakra kire se photocopy pa of a year will die emu awrem kakra nanso se ne legal wife for kan sem no omo wonyina so impo Omaka asa mami Akosua Serwaa bomodin ama we no eye photocopy of dad Lumba we no wode bi man lawyers ya ene eye appeal court won sensem no omukogina de kema lawyers no bitimi provide eye the will of eye dad Lumba etimi aboa ama eye judge na eye temuafo no betena asem no so no watimi edi asem no tentem so kire se we na ebeboa ma asem no ni die no ebetimi akoso no wode photocopy aba na no ana busia ensem yi weto dwane na ebusa se na kobase ya eye baba Jamal na afenso lawyer Fati mu a beginning no mugina mu e wa asem yi mu no omo so ebeti ase anase omo so ebe fight against it ebusia ensem na no ayedin na yenkwa nsem ni nchirimu no emra hye no so aguso yeke black media
kick in so obi koye earlier so you're part of PND's law 111 to obi koye earlier not say on the basis of law no na say bia we ni ho ba oni ma say we no senia esitie no kofo bebre na my information is one hwe ya enko wi ase na wa o ka law no na nkofo bi kura ba be interpret say one can correct because it's like they be some for they be information for Friday eba tis almost say wo wa say ono abanchi na say nya esijano so a munya so almost wo wa send the dan omo de ba so a other party no almost on mehe because no normally there say where wa ehun hia say ele bi akoso that is the law say wo ni wa ina wo fa ele say wo wa fa bibi e fe do probate in so bi say wo wa any do na akofa wo na ba because information akwakoye
procedure say call in and out by it.
I'm patronti baby na no say cuz me call na onim me say on a point of law no ye ba ha ye be camera no then amra ni city amra no say a ye be ka say a b ye be ka say b oh na on a point of law no say well wa yenkoye early say we ni wa in yekoye early say na be ya ye be use PND's law 111 no e dia check ejapade ini say yakoye early na so be say sala we wa say do na odi aba so the person other parties no so be challenge it no. So because I will I say we know I don't want to go into that argument because information I was say about am I and sacrament. Who information and then I will say or channel we say and then I will say or channel we say there might be a lack of privacy their cost. But from the point of law there when who says other first your property the rule who says other first your element. So that is how you should understand it. It's a hotel on I say now what the answer. Because one here that's a original information encophobic as well. Argument but I think the information and too much. One share that who the crap I womb. And then we say, or China we say, and then we say breaking news, or China we say. But as some so the anchor information about no when ya understanding, know how to do the analysis on the point of law. Now, when they go into that situation, they will know how to maneuver or how to go by it. But when the information the point of law, yes.
Yes. I came purposely for you. Mr. Wo, I didn't yes, you person me be say appeal the process no saying and a stages burn documents ni come and how long does it take for the appeal to be finalized?
Question ready. Okay, so over file appeal, over didn't file notice of appeal. So file notice of appeal. Notify court now with the assembly say over so file appeal. Till you several other parties now. Till you several you have to file the substantive appeal and as appeal proper.
Okay.
But maybe within 3 months, and say, oh, Hannah say, untumi apply to the court for extension. Tia ganto extension na. Not say the amount of time would be file. But so one file for extension, I'm a young ganti amount. I say 6 months trim appeal in trim.
Okay.
And so file for extension, I say a ganti amount. Na say o file appeal proper. The court below no ebe boa all the record of proceedings any bibia ajebe fa appeal no wa shepo the court of appeal. But the court of appeal then na ya several parties now we are involved no. Intino o file appeal no so wo na we are appellant no. They say mama Akosua ko appeal obey the plaintiff appellant. Now Odobro so defendant.
Okay.
Intino so no set out the grounds for appeal now. They best serve the parties involved. Then na court na fix it that or best atina or the assembly no. Now they back say appeal no. Eyana most not necessary say ye besa akọ trial senior ye no high court no a obefre witnesses ama ba na ya be cross examine omo not necessary sir, but when the need arises then they can open that door for you. Intino say parties near accept na say obi ayi ni samano a obi okro objection or the beba. So all these processes na ebekoso say Akosua na say court near satisfy say obia can your person can na fi wa mama kwa mama fa alemo addresses na addresses no is either say court ne beka say bia momba me address court no orally just a lawyers ne beka court no ma call address court no orally and now say mom file mo written addresses into written addresses in there obetro no ja come court na ashe data or the bema a judgment. So appeal no ebetuma very fast ebesumi to ache depending upon senior parties na you involved no how they are going to carry themselves up. Obi o ha obetumi the motion aba say ade we kura on tiase obi o ha appeal na mu obetumi the motion aba say yen strike out this record nyoma bebrebe to make pie film and it's a way nyasa motion if any interlocutory motions when nyasa motion that bibia cause smooth there and there by a year or a year and a half there
a year and a half it's about a year and a half sister you fine wow you fine
untie say when year matter in here court na sao.
Oh really?
Yeah. Now there are present matters. Normally in some area in here court no in some area of national interest. So there will be private matter. State talk hana ya kasa ho. Ba o call Ghana wa. Kofo bebre kura nim. Omo adwini ni so. Normally in the pro-political cases, no, and in pain, no, court no fast because in some be edit a court wa omunyan kakran kanwe.
Okay.
Depending upon send your money besi akon, one you go between 2 years.
Hey.
But we dey me my dream na make say my dream no 1 year dey bedru. 1 year dey bedru. 1 year dey bedru because any issue court no dey importance be come sir. Say will be private.
Okay.
They will be private matter. Your issue dey court.
Sister Ifia, me dear no from 2017 to this day me gusu ko won.
Appeal 2017.
Yeah, to this day.
That's how na mo ya no.
Me ni me siblings ye ko won dey word
Inti prestige. Mr. Wo mpacho. Inti bibisa no ebetimi delay property.
Atare ka say ana.
Mpacho ai. Mia.
Me go for it.
Only lawyers can see that you the day for fun ever. I know they do quite.
Na prestige me pacho ma me bisa me question me wie ye.
Question. Or answer no.
Mpacho inti sa no eba ni property sharing na ebetimi affect na na.
Ena na kamba be bisa nimpo.
Yes, definitely. Intimeno, I'm surprised to say Mama Akosua Serwaa ko file early and also quite appeal. So because there are 3 circumstances between aba and are 3 outcomes. One, a bit maba say ye be J Odobro nyaware ne free nsem. E bit mi kura so aba say court be ka say near high court ne kan no ano no. E bit mi kura so aba say Mama Akosua Serwaa na akra na be na ware free nsem. I'm Odobro nkwa ba be the only surviving wife. A bit my banasa because the appeal court no, the 3 justices no, they're going to interpret the appeal based on merit and based on a point of law. To omumu say okra no, my lady during the cry ayo favor or granto the customary marriage now umbetumi cry ajefu nsem. So let's take it like say yemfa ne say ebia Mama Akosua Serwaa na dey na appeal ko. At the end of the appeal no, court ne say onokra no that customary marriage no na undeserve ya je finisem. Nti eba sa na sa letters of administration no say no say agantia man na be den. Because o call for letters of administration because yere. But say onya yere. Tafena ye go back ye could try letters of administration mu ana endu sa time so na ya ganti ama na say wache japade na eno na fena ye go back akwaji je from nsem ana. You see the confusion is going to happen. Tina me ye mo say obekwa appeal agent na o san ko file early. So in short no say appeal nya start pe the issue about early no I was say hot because anything can happen. Because right now, no, Odobro is also a co-wife. What if say a court of appeal can say the high court kind of no.
Prestige na metie wo omo the information cinema omo platforms. And almost say appeal no omo kono nye say woman no sesi ana nye say o the marriage certificate neba na mo or contest say or kotire say Odobro ni ya you like say you no mo dia mo Odobro ni no Odobro ni be prove say ya yere ampa. I don't know bibisa na no mo kam me na menti ase.
I was say appeal there are so many grounds over to me that's why appeal. Over to me ejina grounds cry say the judge erred on a fundamental error of law. Even for a judge in the crown, one grounds could be said judge in the crown or interpreting law with respect to evidence and fact. Yes.
Let me step in. It was me who said it. This is what I said. Listen, there are 3 universal rules and there are 3 universal conditions that grounds of appeal, as per Supreme Court error on the weight of the evidence against justice. error on just as you said, no, on the law and the evidence. But based on what Judge Dorinda said in her ruling as to the evidence at 136 and 137, there are 4 conditions that lawyers know wasn't for court, which has not been made public. Prestige, I promise you, if it is public, I will send it to you. It looks like, or like, Prestige began a bit outside, but they have a grounds of going to challenge Odoboni in marriage to that woman. And that is what Akosua put me. We show that because they are going to challenge Odoboni in marriage, not customary marriage, which was accepted because in their mind, they had no pictorial evidence. It was only one person who came and just suggested that Odoboni is married, and Judge Dorinda objected. So that is it.
In fact, dear, that is a very fantastic way of analyzing it. You are damn right. You are right. I mean, you've analyzed the issue on a point of law. Dear Pacho 9, you've spoken more than a lawyer. 9. So you see how the appeal goes. So the way I appeal, Akosua, there are certain things you have to evoke and you have to see it. And yes, appeal and now appeal. If you miss those grounds now, dear, in fact, why are there? That's right, you are right. Who may say grounds now, dear, akana, and no, you cannot go. But who you should say grounds now, there will be way ABI will be to me and make it leeway. There are many grounds that will be so they are quite appeal. But the idea kind of it fits into the grounds. Make rank and one member I can do idea. Because what share case na course na me who any pay in Korean biawo, some a pay in Korean waha. To her most nebe fundamental error of law. The judge did not apply the evidence with respect to facts. Whereby those staffs na send a dear kind Tino young but when say Miankasa no, I feel maybe analysis about ruling ankasa na ma hwe loopholes wom na ma ba Akosua platform yi so na say ma to me bo na ma check obi ani enyina ehu the possible the strongest part of Akosua Serwaa mama Akosua Serwaa and the strongest part of Odoboni and the possible issues a bit may happen at the Ben said the sports commentary no say bobo sports connoisseurs no omo ya analysis ahansa na ye ba be ye te duro okra na me hia na kodwene dia mo na o ma ba ni nyina yes analysis ni ahwe ye be gina mfimfini ye be on the point of law senior man it ye senior be ya ye wotewa obehu be bia e be possible say asem be tuma dey akọ so it will be interesting today 9 you see every judge is supposed to discharge those principles. And I can give you plethora of cases. Akosua Supreme Court and Supreme Court early those principles said for an appeal to succeed, those grounds must be met and it should be a very strong grounds for you. And no. The weight of evidence.
Example of Akufado and Kathleen.
Oh yeah, and do you know that Akufado is one of the lawyers say open lawyer or appeal no Akosua Supreme Court at the law school you cannot take away Akufado chachuchikata any Akufado lawyer no we any friends
Akutampo
I was
you cannot
just
remember I mentioned those names.
Akufado exactly. Is the most referenced.
Exactly. You cannot take those people out.
Sorry.
Yeah. And the end they will be I feel like law school can own him. The history about Akufado, Chekata, Akutampo, and me my favorite judge, Justice Ahmed Sule. Ahmed Sule is one of my favorite judges.
Oh yes.
Now
I think I don't know trainee what's that this guy Achuguba now they came from the same because Ahmed Sule will tell you in your face the nonsense you did and school you and trash your ruling. He's a known, more or less like Atuguba.
Yeah, now, no, okay, yeah. So you see, Atuguba Senior is a senior to Amadou Sule. So it was Atuguba rather who nurtured Amadou Sule.
Oh,
So
okay.
Atuguba Senior has now retired. So Amadou Sule, So into Amadou Sule, no, ni mate ne, my lord, Pwamai, any Justice Noli Kolendi Krano, or form in terms of rank. Than Amadou Sule senior kakra. Oh,
so Kolendi there, Akufo no promoting to Supreme Court.
Exactly.
Kolendi should be probably at the High Court, and at the if they go in further, we should have been around High Court.
Yeah, Intino.
Yeah.
Intino. Amadou Sule me penasem when he you see when constitutional issues happens, that is when you see the prowess of the judges, because constitutional matters are mostly political. So it was this was a judge who told my lady Isabato Kunu, the former chief justice, and the other panel said they are ruling on the injunction to injunct the Speaker of Parliament, any parliament, from proceeding with the 4 vacant seats, was an aberration of justice. So for a judge to say his colleagues as engaged in an aberration, that is a and ocean dissenting opinion, which say on a point of honor. Oh, my kind of bear 10 times. It was so marvelous. Amadou Sule. Well, there are moments in between fan ho. Boka I think your market versus the Speaker of Parliament 2024. And my friend Markin at the call Supreme Court said the Speaker cannot declare the seat vacant. Constitutional issue.
Yes.
But at that time, he was the only judge who was able to tell the colleagues say what they've done is an aberration. Now, I don't want to single him out, but judges now, most of them are very good. In social appeal now, so now I think we have a lot to learn. Don't say me issue man information be
proceed, I promise you by Monday if the green light proceed by Monday if the green light is given and if documents are shared, I promise you I'll get you a copy.
Mate,
I'll get you a copy.
Mate, because we say you're the legal mind the church here. Now or because I know say Odobroni will case pa Mama Akosua say was no case. But me share me who say my lady Dorenda no judgment not the mine no. Okay, but me name grounds or multi appeal. In this na you bet my analysis no. Na should be assembly okay besa na ebe mo mutie no. Obi understand the beauty of the law. Lord you already at the pa. Oh,
there's one thing that I think I want you to establish there. Pocho, let people know that the case file that is being sent to the appeals court, they are not going to ask them to come with an authentic source, or authenticated document. They are actually going to review the document that was brought in, and then evidence. They are going to talk about evidence and law, and they are going to base their argument based on the evidence at 136, 137. You see, people are saying, "Oh, you are panicking because the appeals court will allow them to bring in fresh evidence." And I also stated there 4 reasons why a fresh evidence will be allowed to pass or be admissible. At the time now, what your case, the document or the evidence wasn't available. They couldn't retrieve it, and they told the court, though, the magnitude of the evidence will have an adverse effect on the outcome. The 4th one, I'm free. But people are making it there. It is just easy for anybody to submit a fresh evidence when these criteria are met. And what is the criteria? First of all, before the case was held, during the case management conference, they pointed out to them the errors in the purported document as marriage certificate. Judge Jarinda gave them the opportunity to bring it. They brought 3 separate documents, which they suggested as marriage certificate. Again, they couldn't prompt the court or the bench to say that, my lord, when we went for authentication, they have given us a month or two to come for the result. Therefore, please hold on. When we are ready with it, we will submit it to court. None of these issues came up. So Dorinda, just as we said, ruled this case based on technicalities. She didn't actually go into the nitty-gritties of the case. She ruled on technicalities that you could not provide an authentic certified marriage certificate. Therefore, you cannot come and tell me in my court there you contracted an ordinance marriage. The conditions were not met. Others are arguing there, they will allow them to bring in a fresh document because it is possible, it is allowed. And I told them, based on aside from the universal rule that is there, the 4 conditions, I've forgotten the fourth one, correct? You can chip in. Based on what you have seen about this case, proceed. Be honest with all of us. Do you think they will allow them to submit fresh evidence? And I also referenced 2 cases. The one that was in 2013, I think it happened in Malaysia, about the map of a land. I forgot the case. And then the one between is it Vodafone Ghana and then somebody about a land dispute, where at the time they couldn't retrieve the document from the Lands Commission. I think it was between Lands Commission and somebody. They couldn't, that was in 2021. They couldn't retrieve the document from the Lands Commission, and the court was made aware. So at the appeals court, they allowed them to submit this fresh evidence, which overturned the ruling from the High Court. Please tell us, do you see any case or any reason why the appeals court will allow fresh evidence from this case?
But let's get this principle straight. So as you said it, the fundamental grounds are also convince the law lots, the 3 law lots at the Court of Appeal, in order for them to allow you to admit the fresh evidence. And I wouldn't boss. Say you must convince them. Say at the time now try no cost you took diligent steps to procure or to obtain those documents, but on Sunday to Mianka, and on the basis of that, Nintino, into me, I'm one kawasem, ama went to me ending kunim. So that is a fundamental ground. I was to me convince you. It's a fundamental ground. Because fresh evidence na ebano, it is either coming to help your case or it is coming to destroy your case. However, no, say when to me lay that grounds na ma court no, anya convince her. Ebe ti said the court no a favor, because ye nyina ya kwakon ina obi a che na hoodin. Ina wo de wa hoodin no entumi amboa, but wako baby ina wakoja ahoodin foforo na opese wo de be fight me. It's a better na wanye fair to the other party. So fundamentally you have to convince the law lord say at the time na need the asem no, you made diligent effort to procure those documents, but on sending to me anchor na sa document no kura mpono se koba sanka on sa kaye at the time na yedi asem na anke betumi asesa asem no. That is fundamental. That is what you should convince them. Into here the popular case of Moshi versus Bejina, that could remember be brief case we amamo. Now how interesting it is. And also a UK case of Lad versus Marshall. Court set out this principle, say in order for you to even talk about fresh evidence, no, you should be able to establish that fact. So let me say I hold this question: whether or not Mama Akosua Serwaa can establish the fact that at the time na yedi asem no, she made, the word is reasonable, diligent effort to procure and to bring those documents to the attention of the court below. In an insa into Mianka. Na sa document anka by mpa anka betuma ma onu nko the only surviving spouse and because all these things is going to emanate from the reliefs no. Oh, relief no do koye no e wana obesate free nti yesu ade na ye besate free the nti o court the reliefs no enum na nsem we nyina be pie free maba court of appeal no kra no say omo ba besate di asem na o mehe the nti o court any near court say okwa they are going to be in that scope. Nti no mo amumisa me ho say at the time o mu di asem no on record no omo catch judge ni say omo find it difficult to bring this document or even omo catch judge ni say omo take this effort say omo person the document way back.
No. No, Lawyer Christie said that he has the original. That if he has it in his office. And Judge,
I'm asking this question.
Outside. No, not at all. No, not at all. No. The answer is no.
No, okay. Exactly what you say. So if the answer is no, then the question is, will you be able to establish that fact? In our here, paragraph 88 ni so meaning na I will say lawyers no so omo can be for certificate who also mo hwe. There are many grounds for appeal. If they can abandon that certificate issue and kebebo because paragraph 88 no it knocks out anything be a fast certificate home because the court was clear from the timer or dismiss the interlocutory injunction. The court was clear on your oshwe. In a ura try no she was also clear on your oshwe.
Let me read the 88 for people to hear.
Okay, read it.
88 was the tendering of this.
Dear, me about answer be reading Mr. Mwanyanum, me mahakra 280. So the likes Mr. 8.3 and you come, Mr. Mum power tap likes because addition I use free DL procedure on the was the dead Mr. Mum power tap need to me sustaining life. And I'm going to give him some roots in your middle roots in your doors or made them out of the normal creation. Omodoso, Mr. Mufa lie on me. Giraffe me, chameleon, lizard, and info from sir, and I'm follow page in my wife. Yeah, but everything I trust me, that's it.
Okay, paragraph 88. The tendering of this marriage certificate was objected to by the learned counsel for the defendant. This objection had been raised during the hearing of the application of the interlocutory injunction on 28th of October 2025. The court rejected the document and advised counsel for the plaintiff to ensure that they complied with the requirement under the Evidence Act. It is therefore a surprise that the plaintiff did not comply with the requirement nearly a month later.
So, in tune say, Ahano, I kind of clear say that was what the court was looking for. Tune say, baby, make I say, men and come here a year more case with moi. Anka, the moment my lady erases herself, and commit me to so cry a delay case no. Initially, me copy and janshi and farmer, and commit to me suicide with unqua Ediamai a yen crembasso. Because Anka, I'll go upstairs and challenge this ruling. Because that was what the court was looking for. Intino, and on you could have applied to the court, say, then court no amount time now, open so taking steps, say, Eddie make sure, say, what to me as satisfy the evidence at na court initiation. And then the now what the court no. So the court will be forced to.
From what happened, can we say that?
Yeah, because I'll go there. So the court will be forced to either deny you or to give you some time. So court no deny it will be a perfect grounds for appeal, or it will be a perfect grounds for sexual right. So court no end the now next amount of time, then that means also court now a variation of no kasa the initial order say episode the assembly term. So copim time on sabe kasa certificate no court need to mean twice. In effect, the injunction and anka pay initially no, which may use harm on saka, meaning the entire argument and money to my 1 year. That is the first thing. But Osha rule in the Muswa, there is no evidence on record say or ye nyamiking in a court in refuse ye. So that means say near court ne kind crown one fine yedma. You were not interested in that. Into no all corners or case who jinasa grants we so for certificate na say enunti me the certificate for bar. You're gonna find it very difficult to convince the judges based on paragraph 88. Because you were given the fair opportunity to discharge that and the one discharge it. So for me, 88 no, it collapses their case. So they be my favorite page, paragraph 88. Because it tells you what the court was looking for. And it tells you the idea of the court. And it tells you that the court also gave you a fair hearing. It also tells you that the court also gave you a fair understanding of what process you should pass through. So failure to do that, no. That's why you have slept on your rights. So you cannot use the Court of Appeal for the Court of Appeal to help you enforce on your right that you slept on, which you were aware. And the Court of Appeal, I'm afraid, will not do that. Even if in an unlikely event, say, or more allow crime and fresh evidence and I say certificate in the bar, then also the law is no sorry. They should fight this to the Supreme Court, asking the court that it will not be fair to them. Then the court should also give them the time for them to interrogate that document. Then the basana yabe mini trial. Una odi aba no ba be try that kem yabe tutu ano. Yini baby onye free baby onye free and it is going to bring a whole lot of issues and it's going to open the floodgates. Tell me can say that document that 88 no say omaka so mu jina so the new document about there, then there should be a fiercely, if the Court of Appeal admit or give them that, they should resist it fiercely, because I don't think it will be right.
Let me ask a question back on some Prestige. Okay. Back when I mean to me beside now when you say when I'm not High Court the trial case in Akosua, say if there is a listener, the plaintiff did not challenge the case and he agreed there was no objections by challenging the like to or not so challenge will be not a judge in the past ruling never was I into almost let me appeal the same case one challenge here man judge like I said my main specific and this win so I think 115. Let me read you here where I'm so do near warrior no the lawyer could see anyway no I will say under cross examination or G2 must say okay or satisfy and say BBC but now enemy to link only we more than more can it seems also a one you some challenge or do near warrior but at the trial court not the High Court no was it DW1 tendered in evidence of the photographs and was it 116 all exhibits admitted in evidence without any objections and they were not contradicted by the plaintiff under cross-examination. Like almost until now, a possible say a dear one challenge I would G2 me baby and no better to me a call challenge or appeal court. That's my question.
Okay, this is a very good question. It could be yes and it could be no. The reason is this. It could be no because one challenge. So why are you coming here to challenge? Since I said they be alone, you have to always make sure say you are coming on the point of law. One challenge. Why are you coming here to challenge?
Sorry, Mama baby in it was a counter claim by Odobroni. In their counter claim, their second relief. So the appeal, I'm sensing that is where they are going to target. But not on the certificate, which, as you said in the paragraph 88, bed destroyer. Odobroni made a counter claim with 3 reliefs, 3 pleadings, and 1 was rejected, and 2 and 3 were agreed, and the 2 was her a customer married to Daddy Lumba. I'm sure that is where they're going to hit.
I think it was withdrawn.
It was not withdrawn. Check paragraph 6 and check paragraph 164. Nothing was withdrawn. You see, in
withdrawn parts now, I've heard a lot of people, and I don't mean to cut you off. I've heard people say it was withdrawn, but it was not captured in the judgment.
Please, it is captured, Akosua.
Miss withdrawn, no. I must say it was withdrawn. Withdrawn, no, was not captured.
Was not captured. No, it is part of the Jawoko
I am a broth na me kind of want to me no kind the same thing. Me say in the judgment, no, I know when a judge and say, although Bruni withdraw the claims, no, into you can't the same thing. What I say?
I agree with you. I am telling paragraph 6 and paragraph 164. Nothing was withdrawn.
It's not captured.
Paragraph 6, that paragraph 6, the second relief is what they are going to hit on at the appeal. So, Monsieur.
Okay. I'm not going to worry.
Maybe proceed and I may buana no answer okay.
Can you proceed?
In effect, no, Mammy Honey Claire, or question, Eugene, or question is saying.
I think I mentioned the same paragraph.
Eugene, but I'm not going to cry. Okay.
Priscilla Nawari, no. It seems that Oma Akusi and challenge or G2 it was says it was not challenged and it was accepted, and as I say, but at the same time now to link Muzu say ko appeal that particular portion. So no means the idea
but to link him but
and my friends and when friends the other then the Oma back for your from and say be my new mudinia but I kind 116 no 9% be 1 say all exhibits were admitted in evidence without any objections and they were not contradicted by the plaintiff under cross-examination. So in this scenario, no, what would be the basis? Are there one challenge here, one objective, also appeal the same case?
I say, it could be yes or no. What I say now, the issue is yes, you can challenge. However, no, over challenge here, you're gonna have a minute chance of succeeding. You're gonna have a very small chance of succeeding, unless you say you'll be able to prove say. At that time, no, Sasem no ebaye no. Now you were not in the known of all the circumstances surrounding that issue, no. So it couldn't give you the opportunity for you to challenge it. But I know crying a bad diamond, but ubit may raise it. But the Ebeman I know Cassia Pani say during the trial, no, one challenge it. When raise it, one can wasem. So it was admitted into evidence and the judge relied on it. So you cannot blame the judge for one kasa wo ineptitude. But what must say? Into a 10% yes and 90% no. Because me dimeni case bia nipa no one challenge one kan ho asem. But Ojina so say at the end of the day no Bana waba court have for justice. So the court main duty is to make sure say justice is served. Even if say one challenger, the appeal court or the court above has the power to correct that error. Let me say no. What some kind of bad thing? But generally, there 90% no. Joka so could use no as a ground, sir. Ebiana win to me answer city. Ebiana win to me answer city. But what must say?
Yeah, Matthias. Yeah.
The senior sorry, and then it's a matter maybe a question here. And then a young friend appear ya walk.
You say Nana could jump into no say I was so to me enough grants or bit my convincing judge and the law and say the entire wave right to challenge. But and also say when they see say justice has not been done, they cannot come in. But what must I say? So that is
Shadi Brown, we the Pacho Mamifa into us, man. Mamifa into us. Show 123 say, I must state that even if they had not contradicted their customary marriage in 2010, per the Ashanti custom and as confirmed by the PW2, which is on the Kantanka, South Kantanka, the expert witness on the customary laws of Ashanti, D2 had become a wife of the deceased. So meaning, na dance odoboni dance ni nkwa na meji tum say odoboni yere be me payment ase. This is because there are varied ways a customary marriage can be contracted, and it goes beyond celebration. The witness gave many instances under cross-examination where the relationship between a man and a woman can be deemed as customary marriage, and I accept his evidence. Timini say baby omoko challenge ni nyan nko ampen ye dije tu mo say odobro ni yere say me writer prestige
a grave to understand say are spread it across the surface. The court can come in and clear everything off for it to be white. But in this case, no, omubenya minimal chance of passing through that draft. Mekura no, ayana me dwuni bibi said. It is so ampa say le Christianka grants kese power ho anka bana nkonkwa appeal. So the new lawyers no, how are they better than lawyer Kusi? Lawyer Kusi said they be anana kojo kala sam no. Oya small lawyers are. Lawyer Kusi oya small lawyers are.
Besides, he has also traveled with this case, so he knows from the start to win.
Or qualified to be a chief justice. It is like we see no onye small isa intimi new do omudi no omudi ba asenu ana anti nkofo abohu ana. Oh, ebia judgment no omuhwemu ya there are salient points bu and then obini mi din komo nipa na ama me paragraph via eto asumu pa. So because omo fa and hot there, then they are making headways kakra. Yes, idea. We know here ebe Pascal Momo. Because appeal, no, appeal. You can say you have the right to appeal, but it's not of right. It should be on grounds of law. It should be on grounds of law. If the grounds of law is not there, they're gonna throw you out. Court now judge catch you say
you've been thrown out because your rate is incompetent. Take the word incompetent. Incompetent in the court panel 30. Hey, ya papa. That is a ukra no utum say the other by na say be paid or so. E yankwasi asam kra e baller kra. And then come momon ka say you're unmeritorious than to say it's incompetent.
Prestige.
Tino, you should be from the baba.
That is why our Supreme Court, in one of the statements, please refer me, I'll say, it is not what is good for good is all good for Ghana. I'm yet to reference that one, but the Supreme Court, on the case of appeal, no, you know that we have a popular saying that says what is good for goose is good for Ghana.
Yeah.
In the Supreme Court case, when it came to the appeal issue, now it is not all that is good for good that is good for Ghana. Especially when people are trying to make a conversation about unloading in fresh evidences or trying to punch holes on what the High Court has already said. That you might think that it is just on the surface. The High Court has already said. You might think that it is just on the surface, just as you are using the word incompetent. You can look at it from your point of view. The judge erred, but if there are other cases to back what she said, just as she said on fact and law or on evidence and law, if the law supports whatever that she said, how are you going to challenge it? How do you challenge what Judge Dorinda has said based on the Evidence Act when she actually categorically said there, even if you go to the Supreme Court or you go to the Appeals Court, it will not stand? That was a bold statement to come from a judge. Who knows there? Probably there's a possibility of you going to the Appeals Court. But she has already. Who knows there? Probably there's a possibility of you going. Feedback. She had already warned you there based on what is available as a Appeals Court. You will not get it. And just as she said, Lawyer Kusi has taken all this about 6 months, almost 7 months, to actually hand over the case to Malo Law Firm, which is associated with Colombia. There is something fishy out there that you are making us aware. Lawyer Kusi to qualified lawyer, Supreme Court judge, and not a Chief Justice. Then there is a problem there. So people should not be too excited about going for an appeal thinking that all is going to go in their favor. I am basing my argument on what Judge Dorinda has said, and I always say that it is going to be on technicalities, purely on the Evidence Act, that your inability to authenticate and then bring a document that actually defines marriage certificate both in Ghana and in abroad. Proceed. Saying all this, and I'm just going to ask you one question. This is a preamble, 2 question and premise on. Do you, as a lawyer, or will you pick this case up and be the lead counsel to adjudicate this case? I just want to ask you.
Me candid opinion in here.
Let me add this before you move on. Based on ethics, probably the legal counsel might punish you for not, but based on morals. So based on morality and ethical professional ethics, what would be your suggestion to this thing?
The issues for the trial were set out by the plaintiff herself in her prayers or in her reliefs, or say declare me as the only surviving spouse. The moment to account are necessary or remove into ordinance, because customary polygamous. So you cannot be the only surviving spouse in customary. Now, the court was being asked to do a specific thing. Declare me as the only surviving spouse. That was a major relief. Into Okono, you should be able to prepare. And I was home who say, a dinner, a bit to declare me as the only surviving spouse, which is here in the ordinance. Ordinance also there, the certificate in ECO. And the certificate must be a certificate which is in force. In law, a free BB laws in force. In a free BB laws. Laws there, law be a law I pass. But it be at the time law no, a war no, na any in force. So for instance, I say Uguta visa. Na visa no, a woman say who multiple travels. But ebia make say visa na expire, but ya revoke no. So one visa no obuku na nko ama nye indicate say ya revoke na ekuta wa. Ebe o te say the visa na active, but in reality na ya revoke no. So if you want to go by ordinance, I will say at the time a nipa ni free muno, that marriage must be in force. Until all the certificate biba na and channel towards that angle na, you cannot win. I think says I know my many gen koye because me say you say all the book biba and a certificate no woman near the womb. Those certificate in womb, what shows say the marriage was in force? What shows that marriage was in force at the time any penny free muno na sa aware na net yase. And for me, that was what the court was looking for. And nothing the court neka say go and authenticate because the other no, it is showing something like a certificate. However, no matter who says that certificate no, it is in force. It was active at the time any penny free muno. Authentication nkwan be to me a flag say na ya active. Without authentication no and to me active and I to me and flag say active and as active. Into which visa year me into which visa year me ama yan cross mu a ebe kuta. So most in the embassy no mo revoke come ka say for passport na yan crossum. In talk of a family book by say family history, Mawarida. The question is, at the time Nipani Wunu, was the marriage in force? That was what my lady was looking for. So if you think say that marriage was in force, use a process to prove to the court say at the time Nipani film, the marriage was still there. To me, based on this understanding, and you could not prove that. Into this authentication, and my lady can not the end of you all say you are the only surviving spouse. That means at the time and papa ni film na o da ho yere nkwa na o yere. So prove say at the time o film na nkwa na o yere. To ko fa book bi I tell say ma ware da. And no tell say at the time nipa ni film na marriage ni active. That is my point. And just want to men prove say I want to get one. You are going to fail. And I think that was why they failed.
But your question.
Simple. Who say who real lives no? And a chair who chair the court no find ma who real lives no? It's like a statute in force and a statute. You can't say statute a law, but there should be a statute in force to define a crime in part. Who can say crime is any offense or any wrong that is explained in a statute in force.